So one of the main differences and generally speaking, the benefit of Wisconsin is we have what's called a direct action statute. And that means that unlike a lot of states, if you have a lawsuit that you're bringing and the party that you're suing, we call that person the tortfeasor typically. If they have liability insurance, you can actually sue and join their insurance company as a party pursuant to their insurance policy that they issued to the person that you're suing. In most states, you can't do that, and the reason being that as the person bringing the claim, you are suing someone else. You're not in privity of contract. You don't really have a relationship with that insurance company. That they didn't issue you the policy. You're not paying the premiums. The person that you're suing purchased that policy or is covered under that policy for whatever reason. And so, like in Iowa, for example, or in Minnesota, if I'm bringing a car accident case, typically you're suing the individual driver, and in some cases their employer, or some other company if there's what we call vicarious liability. But typically it's individuals, not insurance companies. Whereas in Wisconsin, you can typically sue the insurance company. We call it's a third party claim against the insurance company. In most states, you can always sue your own insurance company. So if your own insurance company has not paid out benefits or not done what it's required to do under the terms of the policy, you can initiate an action against your own insurance policy or insurance company. But these are cases where you're bringing a claim against someone else's insurance. And so in Wisconsin, it's nice to be able to sue the insurance company. And sometimes we sue the insurance company and we don't even sue the other driver, although we do typically do it for strategic reasons. But you technically don't even have to sue the other driver if you don't want to. It can help, or at least the thought is that it can help if the jury knows that there's an insurance company on the other side, which is one of the reasons why a lot of states have been resistant to allow that, and the jury is not told about insurance. And there is that belief or that concern that juries are less likely to award damages against an individual, even if they're the party at fault, if they don't know whether the money's coming out of their pocket or an insurance company's pocket. So for that reason, there's a definite advantage in most cases to bring a case that can be brought in Wisconsin because of the direct action statute. I've actually had cases where, let's say, someone was from Wisconsin, drove to Minnesota, got into a car accident there, and we actually pursued benefits. We pursued damages against the other driver in Minnesota, and then filed a separate action in Wisconsin against the insurance company for underinsured motorist benefits. So there are situations where, depending on where things happen, where the parties live, where the insurance policy was listed, were issued or whatever, sometimes we make a judgment call or strategic decision to file in one state or the other because of Wisconsin's direct action statute. Something to keep in mind, and especially for lawyers that aren't from Wisconsin, don't practice in Wisconsin, may not even be aware of the direct action statute. So people have questions about that, or wondering how the statute works, or you're trying to talk through making a decision on which state might apply and where to bring it. feel free to reach out to me. You can comment, or the best way to reach out to me is just go up to the link tree and you'll find the little icon and just send me an email. So hope that was helpful. And until next time, everyone, have a good one.